So when your client is a trustee or an estate trustee and asks, can I pay my legal fees out of the estate? The answer is yes, but then you need to explain that that source of liquidity, which is essentially what they're treating it as, can be cut off. The court could appoint an estate trustee during litigation. The court could order a freeze, and the client could be forced to pay everything back.
We've talked about the NDAs. There might be confidentiality provisions in the LOI, or it might specifically reference the separate confidentiality agreement. And in any event, we want that to continue and be binding, even if negotiations break down.
The only other thing I would say on the power to borrow is that in order for the estate to maintain its testamentary trust status under the Income Tax Act, the trustee is restricted actually from borrowing funds unless it's to pay for expenses, and or borrowing funds, let's say from a beneficiary, because the estate is illiquid and now I need to bring money into the estate from somebody to cover expenses and reimburse them later. I think it's an important fact that from an administration perspective, that I think the rule is, and correct me if I'm wrong, that they have to be paid back within the year in order for the estate to maintain its testamentary trust status.